appeals process for the 350 Social Relief of Distress grant has been reopened. It's for people who've applied for the grant and were turned down from April this year. Let's speak to John Mokoele, Director for Pre-Adjudications and Operations at the Department of Social Development. A very good afternoon to you, sir. Thank you for your time and your patience. So this process opened on Monday. We're on Wednesday now. How many appeals have you received?
Yes, thank you very much for your time as well. I think what we have done is that we have opened the systems on Monday, the 27th of April, of June, in fact, on Monday, the 7th of June. And so far, up till today, before lunch, we had received 563,031 appeals. That's the number of appeals that we have received so far.
And are you able to give us an idea of the grounds on which those people had their applications declined?
Many of the reasons for decline is that the people have alternative income. People have been excluded the self-exclusionary question that says people have responded to saying that they have got money in their account. And there are those that have been excluded by reason that they are appearing in the NSFAS database, and that also they are appearing in the other databases that SASSA check against to ensure that they verify their credentials if they indeed qualify for the 350 grant.
They are now appealing 563,000 appeals you've now received. What is the margin of error in your vetting process where, in fact, you may have to now overturn that earlier decision to decline their applications?
We have not yet made that determination because we still have to make sure that we process them accordingly, because what we are going to do is that we are going to sort them according to the reasons so that we are able to make sure that the determination that has been made by SASSA to exclude them, it is a valid reason. If people have been excluded for alternative source of income or for appearing on the UIF or whatever database, we are able to confirm or ascertain if indeed that has been the case. So we have not yet made an assessment that says this is what we have discovered, the error, the margin of error by SASSA is this much.
And in terms of the waiting time, how long will people have to wait to hear back from you on these appeals? Because many of the people who've applied, yes, it's one thing to talk about the ones who may be trying to defraud the system, but those who would be applying out of genuine need would desperately need this money because they don't have any other money, and even those of us with salaries are already battling, so they would be quite desperate to hear from you quickly.
Yes, indeed, that's what we're trying. Remember, the provisions provide for us to give outcomes within 90 days period. But what we are trying to do is that we are trying to say by the last week of July, meaning from the 25th of July, we'll start giving outcomes. Because what we have done is that we have put together all the numbers that have been received of appeals, specifically for the June. Because remember, SASSA has, at this point in time, only adjudicated applications or considered applications for June. So what we'll be doing that by the end of July, starting from the June, we'll start giving outcomes for these appeal applications, and then we'll then start rolling out also subsequent applications that we might have received. What we are saying is that people have to lodge appeals at from 30 days to 90. They've got 30 days to 90 days to lodge appeals against the decision made by SASSA.
Right.
So what we are appealing to people that they should not wait too long for them to lodge appeals.
So SASSA has in recent weeks also amended the terms for qualification. One of them, rather controversially, is that people who receive financial support, say from a friend, a family member, on a regular basis or whatever the spread of that money is, would also be considered people who've got another income. Are you applying that now to these appeals, considering that they go back to April?
Yes, remember what we do is that we're looking at what the current provisions of the law are in terms of grant application process, what the SASSA was expected to consider, and we are going to check against that to verify if indeed people have alternative source of income, because you must also understand that there's a threshold of 350 rand at this point in time, that a person who's received income from whatever source that is above 350, that person will not be in a position to receive the grant. So that's what we'll be looking at, and because there's no new evidence that people are going to be expected to submit to justify why they are receiving that alternative source of income.
But is it really fair, Mr. Mokoele, to say someone who's receiving financial help from a friend or a relative is in the same category as someone, let's say, who's an NSFAS beneficiary from a student loan?
Remember, also people are receiving NSFAS, they are being excluded. So the same way that, because they are receiving stipends.
Yes, but I'm asking is it really
NSFAS,
the same thing? Because it's one thing to get money officially from a student loan that's helping you to basically buy food and other supplies while you're studying. It's a whole other thing to have, say, a cousin who, when they have money, sends you, let's say, 400 rand to help you get by.
Remember what we are saying, that we are looking at people who are desperate, who do not have any source of income, who do not have that kind of support from cousin, from friends, or whoever. Those are the people that we are looking at, who we believe deserve to get a 350. So those that have a helping hand, we believe that they are not desperate as those who do not have anything. That's what makes the difference between those that are getting and those that are not getting.
Is the application or the process by some of the NGOs to take you to court over what they say are exclusionary qualification criteria, is that a consideration at all at this point, or will you only deal with that once a court has actually pronounced?
Yes, we'll only do that once the court has already made a pronouncement on those challenges. Because at this point in time, whatever it is applicable is what the law is providing for. If the court made a ruling that says what you are doing is unlawful or is not in line with what the Constitution expected you to do, then we'll have to come back and review our law as well, so that we remove these impediments that the court may have determined to say these are impediments to people getting the grant. Please make sure that they do get the grant.
Thank you for your time, sir. Mr. John Mokoele from the Social Development Department. Good to speak to you.